The property may just be in a location where water collects for a short period of time until it either percolates into the ground or runs off. Flooding can also come from sprinklers and irrigation that are not aimed correctly at the house and could cause mold and foundation issues. In real estate, material facts are any details about a property that could influence a buyer's decision to purchase, or the price they're willing to pay. When it comes to water damage and flood history, material facts specifically include any information about past or current conditions that affect the property's safety, functionality, value, or insurability. Material facts related to water damage and flood history include past flooding incidents, whether caused by monsoons, broken plumbing, poor drainage, or nearby bodies of water, standing water or recurring drainage problems on the lot or adjacent properties, mold or mildew resulting from water intrusion, repairs or remediation done due to prior water damage, including whether it was professionally handled or DIY, known location in a floodplain or FEMA-designated flood zone, flood insurance claims or requirements, water intrusion into basements, garages, or lower levels during heavy rains, grading or landscaping issues that affect water flow toward or away from the structure, why it matters. Buyers rely on full disclosure to assess risk and cost. Water damage can lead to hidden structural issues, insurance challenges, and long-term maintenance concerns. Sellers are legally obligated to disclose material facts under Arizona law and most other states, and failure to do so can result in contract termination, lawsuits, or financial liability. In Arizona and most other states, a seller has a legal duty to disclose known flood issues that could materially affect the value or desirability of the property. This duty comes from both common law principles of disclosure and specific statutes or contract provisions. Seller's duty to disclose known flood issues. Material. Facts must be disclosed. If the seller knows the property has experienced flooding in the past or is located in a FEMA-designated flood zone, they are legally obligated to disclose this information to prospective buyers. This includes past flooding incidents, even if minor or from monsoon storms, standing water or drainage problems, claims made on flood insurance, known location in a flood hazard area, flood damage repairs, issues with flood insurance premiums or availability, Arizona's Seller Property Disclosure Statement, SPDS. Arizona Association of Realtors AR provides the SPDS form, which includes specific questions about drainage, grading, flooding, and insurance claims. Sellers must complete this form truthfully and to the best of their knowledge. Questions may include: has the property ever flooded? Are there drainage problems on or near the property? Has flood insurance been required or obtained? Cannot conceal or minimize. Even if a buyer doesn't ask, the seller can't withhold flood information that could affect the buyer's decision. Intentional concealment can lead to legal liability for fraud or misrepresentation. Disclosures must be made before contract acceptance. The seller should disclose flood-related issues during the disclosure period and before the buyer commits to the purchase. If disclosures are made too late, the buyer may have the right to cancel. Key takeaway: if the seller knows about any flood-related conditions, they must disclose them. Failure to do so can lead to lawsuits, canceled contracts, or even damages after closing. Seller's disclosure obligations, regardless of insurance claims. In Arizona and most other states, sellers must disclose all known facts that could materially affect the value or desirability of the property, whether or not those issues were ever covered by insurance. This includes past flooding or water intrusion, even if no claim was filed, damage that was repaired privately or without involving an insurance company, ongoing drainage or grading issues, even if the property hasn't recently flooded, problems that occurred under previous ownership if the current seller is aware of them. Why this matters. The duty to disclose is based on what the seller knows, not whether an insurer was involved. Just because no claim was filed doesn't mean the issue didn't happen, or that it can't affect the buyer's use or enjoyment of the property. Omitting known issues can lead to contract disputes, lawsuits for misrepresentation, or financial damages later. Example: if a seller had a heavy monsoon flood in 2021 that left standing water in the backyard and seeped into the garage, but never filed a claim, they must still disclose that incident on the SPDS, Seller's Property Disclosure Statement. Even if they cleaned and repaired it themselves, the event is a material fact. Legal implications to the seller. If flood zone map updates are unknown, if recent FEMA flood map updates reclassified a property into a high-risk flood zone, such as from Zone X to Zone AE, and the seller is genuinely unaware, the legal risk is typically limited, but not zero. Good faith standard. Arizona and many other states follow a good faith disclosure. This means a seller is only required to disclose what they know or reasonably should know. If the map update occurred after the seller completed their disclosures or without any notification to them, they likely won't be held liable unless they had reason to know, e.g., they received a notice, property tax bill with new flood info, etc. But if the seller should have known, if the seller ignored obvious indicators, like notices from the city, a lender, or insurance changes, they could be accused of negligent misrepresentation or failure to disclose a material fact. Buyers can sue if they later discover the property requires flood insurance and feel the information was intentionally withheld or misrepresented. Due diligence shift to buyer. Once under contract, the buyer has the responsibility during the inspection period to verify FEMA flood status via overlays, flood zone determinations, lender review, etc. If a buyer fails to do this and the seller acted in good faith, liability is unlikely to fall on the seller. Bottom line, if the seller had no knowledge of the map update and made all required disclosures truthfully at the time, they're likely not liable. However, if they ignored or concealed official information that could have alerted them, they could face legal action for non-disclosure. Just because the seller does not know about latent or material defects in and on the property, it does not mean that it lets the buyer off the hook. It is up to the buyer to do their due diligence and make sure that they know all there is to know about the issues and property details prior to closing. In Arizona, there are several key disclosures related to flood zones that sellers, landlords, and real estate agents must be aware of to ensure legal compliance and protect all parties in a real estate transaction. Main flood zone disclosures in Arizona. Material fact disclosure. If a property is located in a FEMA-designated Special Flood Hazard Area, SFHA, such as Zones A, AE, AH, or AO, this is considered a material fact and must be disclosed by the seller, even if no flooding has occurred. Known flooding or water intrusion. Arizona law requires sellers to disclose any known past flooding, drainage problems, or water damage, regardless of whether an insurance claim was ever filed. This includes recurring ponding, roof leaks, foundation seepage, or historical flood events affecting the property. SPDS, Seller Property Disclosure Statement. Arizona's standard residential purchase process includes the SPDS form, where sellers must answer questions about flood history, drainage issues, and whether the property is in a floodplain or has required flood insurance. Flood insurance requirement. If the property currently requires or has carried flood insurance, that must be disclosed to the buyer, even if the requirement arose from lender or FEMA flood zone determinations. Updated flood map. Impact. If a flood zone change has recently occurred or may impact the property due to a FEMA map revision or a letter of map amendment, it should be disclosed if the seller is aware, even if they haven't been officially notified. Floodplain restrictions. If the property lies within a regulated floodplain and there are restrictions on building, remodeling, or development, those limitations should be disclosed to prospective buyers. Agent disclosure duties. Real estate licensees have a duty to disclose any flood-related risks or conditions they know about, even if the seller fails to mention them. The worst flood zones in Arizona are typically areas designated as Special Flood Hazard Areas, SFHAs, by FEMA, specifically Zones A, AE, AH, AO, and VE. These are areas with a 1% or greater annual chance of flooding, also known as the 100-year flood zone. However, in terms of actual geographic risk, certain urban and rural areas stand out due to topography, drainage issues, or proximity to washes and rivers. High-risk flood zones in Arizona, worst areas: Maricopa County, Phoenix metro area, South Phoenix, Maryvale, Laveen, and areas near the Salt River have extensive AE and AO zones. Flash floods and poor drainage during monsoons pose significant risks. Urban development near canals, washes, like Skunk Creek and Cave Creek, and low-lying desert valleys heighten flood danger. Pima County, Tucson area, flood-prone areas along the Santa Cruz River, Relito River, and Pantano Wash. Many homes near downtown Tucson, Vale, and Marana fall into Zone AE or AO. Sheet flooding and ponding during monsoons are common in these areas. Flagstaff, Coconino County, areas below the museum fire burn scar have seen major flood damage from post-wildfire runoff. Zone A and AE areas below the mountain slopes are particularly vulnerable due to steep terrain and erosion. Yavapai County, Prescott and Cottonwood, flooding occurs near the Verde River, Granite Creek, and Oak Creek. AE zones follow waterways that overflow during heavy rainfall or snowmelt. Gila Bend and Wickenburg. These towns are prone to devastating flash floods due to dry washes and desert terrain that can't absorb water quickly. FEMA maps often show large swaths of Zone A without detailed BFE, requiring elevation certificates. If a home in Arizona is destroyed by flooding before closing, the situation is governed by a mix of contract law, Arizona statutes, and the terms of the residential resale real estate purchase contract, as commonly used in Arizona transactions. Here's what typically happens. 1. Contract determines who bears the risk of loss. Under the Arizona Residential Resale Real Estate Purchase Contract, AAR form, the standard clause is Section 8C, Risk of Loss. If prior to the close of escrow, the premises are damaged or destroyed by fire, vandalism, flood, earthquake, or act of God, the risk of loss shall be on the seller. If the cost of repair exceeds 10% of the purchase price, the buyer may cancel the contract and get their earnest money back. So, in short, seller bears the risk until the transaction closes. The buyer has the right to cancel if the damage is significant, over 10% of the purchase price. If damage is minor, the seller typically must repair or compensate accordingly. 2. What if the home is a total loss? If the home is destroyed completely by flooding, it very likely exceeds the 10% threshold, giving the buyer the right to cancel and recover all earnest money. Even if the buyer wants to proceed, the home may no longer qualify for financing or insurance, making closing impossible unless the terms are renegotiated. 3. Insurance and legal claims. If the seller has flood insurance, they may be entitled to a payout, but that payout does not automatically transfer to the buyer unless agreed in writing. A new contract may be required if the buyer still wants to purchase the land or a damaged structure at a reduced price. 4. Buyer options. Depending on the extent of damage, the buyer may cancel the deal and walk away with their deposit, negotiate repairs, insurance proceeds, or a price reduction, if damage is under 10% and they want to proceed. Seek specific performance if the seller refuses to disclose or deal in good faith, though that's rare in flood cases. Real-world example: if a monsoon flood destroys a home in a Zone AE floodplain 3 days before closing, the buyer can cancel if repairs exceed 10%. If the buyer still wants to proceed, financing might fall through unless the home is rebuilt or repaired first. The seller's insurance company would be involved, but the buyer generally doesn't benefit unless it's part of the agreement.